Supplementary list, fresh admission item number 1.
Vinay Kumar Mohanty.
My lord, I am in virtual mode.
Yes.
My lord, the petitioner's grievance, my lord, they have prayed for a direction to OP number 4 and 5, the collector and Tahsildar, to settle the land in favor of the college, my lord. SBM college, which is an autonomous and a composite college, my lord. In view of the decision, policy decision of the government and the gazette notification of the government. And
How is this a PIL, sir?
My lord,
Why is this a PIL?
College has never approached this honorable court.
Why is this a PIL?
PIL, my lord, the public interest, my lord, is involved in the case, my lord, because
What public interest?
And you
interest, my lord, the college, my lord, college, the collector is going to demolish the wall of the college.
What about the college, sir? Why is the college not coming forward?
They have encroached 21 acres, more than 21 acres of land.
Why is the college not coming forward, sir?
My lord, they have the public, they have represented college, my lord, annexure 4, college has given also represented.
No, why is the college not the petitioner here?
Is not coming before this honorable court.
Why?
My lord, college, we have also made the college as parties, my lord.
No. The affected party is the college. Why is it not coming forward?
College is also with us, my lord. College is also
No. With you means there should be the petitioner. Then this is not PIL.
PIL, my lord, the several meetings.
The court is not satisfied that this is the question of demolition of a encroachment by the SVM Autonomous College Jagat Singhpur is a matter for public interest, particularly since the college itself is not before the court as a petitioner. The court therefore declines to entertain the present petition. This will not prevent the college, if it is actually aggrieved by the actions of the other opposite parties, to seek appropriate reliefs in accordance with law. The petition is dismissed.
Well, dispose of your lordship, dispose of.
No, nothing, sir. This is PIL.
Supplementary list item number 2.
All the annexures are in Odia. I may be excused because only I pray. These petitioners are the members of the Bonasarthi committee as well as the inhabitants of the locality. They are looking after the forest since last 40 years and there is a good forest growth. In the year 2017, a decision has been taken to.
Anyway, your representation is there.
Manner. Resolution was there.
No.
5 acres.
Representation.
Yes,
representation dated 11th November 2021 will be examined by the.
My lord, that is annexure 5 series. That is to the central government, and copy has been given to the state government. The collector has to. The 5 series has been given to the collector as well as the DFO Baripada, since they are the authority, immediate authority.
What is this annexure 6?
Annexure 6 is a reprint subsequent reprint government of India with a copy to state government as well as the DFO, collector, everybody.
Why are you? This government of India is not even a party here.
No, my lord.
Then
I am not.
You're going on making representation to government of India.
No. I am 5 series. That is the representation to the state government authorities.
That is some 3 years ago, sir.
No. Last is 1/6/2020, my lord.
20.
And this representation copy has been given to all the authorities, state government authorities. Annexure 6 also.
That is also page 43 to the Secretary, Forest and Environment Department, not to the collector, I think.
No. Last page.
Page 43.
46, page 46. Copy to.
Where is the proof of that? 46.
Yes, my lord. I have given the postal receipt.
What is the date of this 46?
46 is 11/11/2021 and postal receipts have been annexed, my lord. That has been sent on 23/11/2021.
But it's addressed to some central government.
Yes.
No. Copy
to...
has addressed to central government. Copy has been given to the state government. If your lordship permit me to file a fresh representation before the collector Moirvanj and divisional forest officer Baripada,
petitioners are permitted to file a fresh representation to the collector Mayurbanj
copy number 3, my lord.
On or before 25th April 2022, in which case He said representation shall be examined, and after hearing the petitioners, the reasoned order shall be passed thereon, not later than 11 July 2022. A
All right.
copy of the order shall be made available to the petitioners not later than 18 July. Court clarifies it is not expressed in the matter.
Supplementary list item number 3. Item number 3.
My lord, I am on virtual mode, my lord. Well, I am in virtual mode, my lord. The petitioner before your lordship. Sir,
Election
my lord, I
list.
am-
What is the selection list?
Selection list, my lord, that is the pre-test examination annexure 3, my
This is
lord.
all service matters, sir. We don't interfere in PIL.
No, my lord,
There can't be PIL for service matters.
my lord, the single bench has passed the order while hearing the matter. This is a virus involved in this
No,
case.
no, no. But this is not a PIL, sir.
No, no, PL, this is not PL, WPC 3, my lord. My lord, virus is involved in this case, my lord.
No, no.
That's why
Virus
this-
will go to the respective benches. We have actually said that.
Your lordship has given concurrence, my lord. On the noting of the single judge, my lord, your lordship gave concurrence. Thereafter, this matter has come before lordship. Your lordship may kindly read the order of the single judge, my lord. Single judge, while entertaining the matter, hold that the virus is involved in this case.
No,
Challenge
all
of-
virus matters don't come to the Chief Justice anymore, sir. Virus
Well-
goes to the respective benches.
No, probably
Your
when a
lordship has-
single bench matters in service matters which are assigned to honorable single judges. In those cases, virus probably it has been directed to be listed for division.
This
bench.
court, is it? All right. All right. Notice Mr. Moduli
No,
accepts
your lordship may
notice.
kindly see there are two prayers. One is validity of rule 22, sub rule 2 under challenge. The another is he challenged the selected and none of the selected persons are made parties to the writ petition.
No. I have not. I have only pre-selection list. I have challenged, not the selection list. The pre-selection. This is the
But
pre-selection.
you've termed this a selection list.
It was the selection list dated 18/3/2022 under annexure 3.
Yes.
Your lordship may kindly pre-selection list, not selection list, my lord.
Pre-promotional.
Pre-promotional test,
Ultimately, they will be
Not-
affected.
not the final selection. Not this is not the final selection list, my lord.
Anyway, notice Mr. Moduli accepts notice for opposite parties. All of them.
Yes.
Replies be filed within 8 weeks, rejoined up for the next date. All actions taken in the meanwhile will be subject to the outcome of the petition. The IA is disposed of.
Obliged, my lord.
This after 20.
Supplementary list item number 4.
Thank you, Your Lordship. I am on a virtual mode, ma'am.
Yes, sir.
But in this case, the petitioner also filed the writ petition to implement the order passed by the Tahsildar under Annexure 7. The order of Tahsildar was passed pursuant to the order passed by the Commissioner and Board of Revenue member. Simultaneously, both the order passed by the Commissioner and Board of Revenue member were also challenged by the government. And on basis of the order passed in this court on 2/8/2019, so both the cases were analogous and was posted for hearing for analogous hearing. In the meantime, the status quo regarding possession of the petitioner was granted by this honorable court on 2nd August 2019, page 4 of my IUP. But at the time of hearing, my lord, your lordship set aside the
Actually, my
order
lord has directed to maintain the status quo till disposal of that revision case. But that has not been reflected in the order inadvertently. I think his prayer is that status quo order, which was in operation from the date of filing of the writ application, that is to be extended till the, I think this
Disposal.
is the relief sought for by the petitioner.
All right. You say this IA number
And consequently,
2656, all of these
the
IAs.
date of filing of the revision and disposal, that
Yeah.
should be extended.
Yeah.
page
order
6
dated-
I have put it.
The order dated 15 February 2022 is clarified by directing that the status quo order passed by this court during the pendency of the writ petitions will continue till the disposal of the
Consolidation revision case.
consolidation revision case.
61.
No,
In one
respective
case, respective
cases.
consolidation.
Ah,
That is better. Respect.
yeah, respective consolidation cases.
And the date of disposal of that may be extended because
Yeah.
that is also his prayer.
Further, the time for disposal of the said consolidation revision case.
Page 6, I have put it there. Page 6 of my I have put it what to be modified.
Is extended till
The end of June.
4th July 2022. And the orders to be made available not later than 11th July 2022. The IAs are accordingly disposed of. All right.
Read petition may can be disposed of accordingly because it was dismissed. Your lordship directed to dispose the same in view of the order. That is why I have put it in page 6 of my IA.
Doesn't matter, sir. Somebody has to read the whole order.
And
No, because on all the three writ application, your lordship has directed the writ petition is dismissed because it matter is remanded. This dismissal order may
Acha.
affect the interest.
It is further clarified that the writ petitions were disposed of and not dismissed. All right.
Supplementary list item number 5.
all the matters.
Yes, yes.
All the matters same order.
And the other matters, the revision must be changed, my lord, because they have wrongly entered as the revision 61 everywhere.
So wrongly entered as
61 of 2000 in
No,
every
perhaps your lordship has not mentioned any number, respective consolidation revision cases.
correct. Yes.
Supplementary list item number 5.
None appears dismissed. No.
Supplementary list item number 6.
My lord, in this case, this is the similar order to my lord's order dated 19 February 2022. This is the copy. This is regarding, my lord, I may recollect that this is regarding the Bolarpur industry, my lord. My lord is a granted stay that is pending before NCLT.
Okay.
That is similar. This is the also same. Same, my lord, same prayer.
Sorry.
Counsel, the petition states that the present prayers in the present petition are similar to the prayers made in the petition civil PIL number 6779 of 2020, in which an order was passed by this court on 18 February 2021, disposing of the writ petition, issuing certain directions. Full stop. There is no status quo order as far as this present petition is concerned, sir.
My lord, in that writ application, my lord granted the stay in the matter of conversion of land, which is pending before NCLT, National Company Law Tribunal. My lord.
No, but here in the present petition, there is no stay.
No.
There is no stay.
There is no stay.
No stay.
In terms thereof, the following directions are issued. Opposite parties five, 4 and 5 will not will ensure that there is no request for mutation of any land of opposite party number 6 to 8 during the pendency of the proceedings before the NCLT and without prior permission of the NCLT. Next, to be open to the petitioners to participate in the proceedings before the NCLT and make their submissions in accordance with law. The petition is disposed of their victims.
Supplementary list item number 7.
Marshal, item 7, the virus of Latitude Order 2004 is under challenge. Marshal, posted similar matters to 7th of July. If you'll actually permit, I'll give the lead number of the batch matter.
Yes.
Copy has not been solved.
School and mass education is the party.
Oh, school and mass. I'm sorry.
A WPC number 23222 of 2020, Your Lordship.
List along with 23222 of 2020 on 11 July.
On 7th of July, Your Lordship.
7 July 2022.
Obliged.
Supplementary list item number 8.
Wait, please, Your Lordship. My Lord, this is a fresh admission case. During pendency of this writ, they have made a notification on dated 21/3/2022. So, Your Lordship, I have filed one IA for amendment, and to avoid the delay also, I have filed consolidated writ petition. My IA is 4089/2022. And it is a consequential only. The virus of the notification under Annexure 3 is already under challenge.
All right, 4089 is allowed as prayed for. The consolidated writ petition is already filed.
My Lord, to avoid the delay, I have filed. I am extremely sorry for this, Your Lordship. I have already
delay is condoned. The delay, consolidated writ petition is taken on record. Notices to go in this.
My Lord, notices to go, but there is a very urgent interim prayer involved. Your Lordship, is a very strange notification the government is making. Very simply put, Your Lordship, the government notification says that a person having MSc qualification will be given less preference than a BSc qualification. It's just like that, Your Lordship. My Lord, may kindly see what they have done. For the post of junior fisheries technical assistant, they say that a candidate having +2.
Yeah, they don't want overqualified people.
Yes, Your Lordship. This is very strange.
Not strange, sir. That could have a logic to it. Sometimes overqualified people, you find it difficult to make them work.
I am not overqualified, Your Lordship. That is only, Your Lordship, may kindly see what Director of Fishery himself has written. Annexure 3. And I have also given the notification of State of Andhra Pradesh.
Anyway, let notice go. Mr. Mudli accepts notice for
1 and 2.
Opposite parties 1 and 2. Notice to the
Extra copies.
opposite party number 3 were registered, 3 post returnable on the next day. Since Mr. Mudli accepts notice, extra copies be served on. Replies be filed within 6 weeks of service of notice to join up for the next day. This on 22nd August.
My Lord, my prayer, my Lord, may kindly see my interim prayer, Your Lord, I have made. That is IA number 4088/2022. Your Lords, may kindly see the Director of Fisheries himself has written that this is something wrong they are doing. Annexure
All
6.
appointments made in the meanwhile will be subject to the outcome of the writ petition. This IA 4088 of 2022 is disposed of. What is 4089? That's allowed.
That is 4089 allowed. Another IA is there. Your Lordship, in that case, Your Lordship may permit the petitioners to, because
Put on
20
both the IAs, IA 687 and 4088, and this subject to the outcome of the writ petition. Both are discussed.
My Lord, my only prayer is that since in the fresh notification, they have given the date, that is 22nd April, we have to apply. So, Your Lordship may kindly permit the petitioners to apply, and their participation in the process will not hamper the merit of the case, in arguing the merit of the case. Because once I participate,
What's the question of participating? If you are not qualified, you're not qualified.
No,
sir.
my lord, I am qualified. I am possessing better qualification. The prayer
So
is
why
that
should we permit you to participate? Then you participate.
once I participate, your lordship, after filing the writ petition without permission of this honorable
All
court,
right, you
lateral.
say the participation of the petitioner in the selection process would be without prejudice to the rights and conditions of the petition.
Yes, your lordship.
All right.
Obliged, my lord. My lord, may I pray this, since this involves the career issues of the persons, 22nd April is the date, last date fixed. Can it be on any earlier date before that, your lordship?
No question, sir. Where's the question? First, replies have to be filed. Pleadings have to be completed.
Supplementary list item number 9.
Yes, sir. Let it come next week. In the meantime, I will remove the defects.
Okay. Counsel, the petitioner states defects will be removed within a week. List thereafter.
Supplementary list item number 10.
My lord, I have challenged the granting order of 2005, my lord, 4 months.
So many defects, sir.
Defects.
Counsel, the petitioner states defects will be removed within 1 week. List thereafter.
Supplementary list item number 11.
Item number 11, your lordship, I pray for 1 week time for removal of
Removal of defects. All right. Same order.
Supplementary list item number 12.
May I please tell you? Well, similar matters, your lordship have been pleased to as reserve the judgment on 5th of this month or retirement at 65. So I pray that this matter may be tagged to the
orders reserved along with
WBC number 13666 of 2020.
All right. 13666 of 2021. That must have been 2021, sir. 13666.
It is 20.
20.
13,666 of 2020.
All right.
And other matters are also in 2021.
Right.
Well, I have a grievance, my lord. Well, your lordship, kindly have in this supplementary list also itself, the noting is that the honorable court have been pleased to direct that both sides printing of petitions and affidavits in the High Court of Orissa will be permissible with effect from 1st November 2021 at the option of the filing lawyers / parties by notification number 1090/R dated 28/10/2021. So we are filing both sides of printing before this honorable court. But yesterday I faced difficulty. The receiving officer of the Advocate General refused to accept my copy on the ground that both sides of printing have been given.
Of Advocate General Office?
Yes, receiving officer copy. I have given some of the...
All this, we are not getting into all this, sir. That you sort out with Mr.
That
Mon.
is between us. Why are you mentioning it? You tell us. Anyway, you give the copy,
yes.
I will take.
Yes. But my request is that they should be informed.
Okay.
Both sides, I refuse.
All right, sir. We are now have the matters going. Call up the next matter.
Supplementary list item number 13.
Encroachment of Gochar land by opposite party number 5.
Opposite party number 5 and others. My lord, the opposite party number 5 is the surplus. Right? Some of the taking some grant, he is digging the entire Gochar land, my lord. Most of the lands are also encroached and
shall be examined.
Page 20.
Examined by the Tahsildar Balapar.
Video. Oh, Tahsildar should have been. Yes, my lord. Page 19, Tahsildar Baliapar.
Tahsildar Baliapar.
Page 19.
After issuing notice to the petitioners as well as opposite party number 5 and giving them a hearing, the reasoned order should be passed not later than 16th May 2022. And we not 16th, we just say 20th June 2022 and be communicated to the petitioners, to the parties, not later than 27th June 2022.
In this case,
my lord, my small player, their digging is continuing and they are just creating a artificial pond, my lord. There is no land is at all available.
In this case, I am answering for the OP number 5. The government has given money for development of the land. There is no question of a pond.
Anyway, he'll hear you, sir. The video will hear all of you. The court clarifies it has not expressed any view on that.
Supplementary list item number 14.
My name is it.
All right.
Item 14, may I plead your lordship?
Yes.
It's before your lordship. Regarding illegal detention, your lordship. I have been
Put to inside the custody more than awarded sentence, your lordship.
Correct, correct. What is the response, Mr. Katkia?
Well, there is no illegal detention. Absolutely, sir. Absolutely, there is no administrative laxity in this case. Plus, the order has been communicated. Plus, I have given another additional affidavit. That is in some further affidavit that I have filed on. I am serving a copy on my land not because in due course that order has been communicated to the jail authorities, and they have calculated the period, and subsequently after getting the order from the Ladin court below, he has been released. Now on bail below, even he has not been finally released. That is the reason below what they are saying, because here in the judgment, Los Miguel Perus at page 23, delivered by the Honorable Court, there the fine amount plus has been modified. Earlier it was rupees 5,000 in default to honorable RI for a period of 1 year. That has been modified to 10,000. So I have annexed one document that is a jail rules that also I have quoted. So they, it is my humble submission for Lordship is substantive commutation is always made against the substantive sentence, not against the fine as per rule section 428 of CRPC. So here fine amount has been imposed, increased to 10,000 in default to honorable RI for 1 year. So right from the date of judgment that has been passed on 4/8/2009, from that date they have counted, so that even within that period he has been released.
When was he actually released?
3/8/2010 he has been released. Even if a lordship will pass an order that he should be released forthwith, still the person can be released within 1 day or 2 days, because that has to be communicated to the Learned Session Judge. Then Learned Session Judge has to pass a release order in his favor, because he has remanded the prisoner. So this is in no way administrative laxity. It cannot be said to be illegal confinement. So what is the reason why the jail authorities will put him behind the bar for no reason?
Carelessness, sir. Not caring.
Well,
not caring enough. Somebody else's liberty, so not caring enough.
No, they have. No, so I am showing that. You also can peruse the affidavit. Further affidavit I filed on 31st March 2022. There was I have page 2. I have quoted that rule.
That is not served upon us.
More copy. Yes, I am serving a copy on him. Well, my land has not got it. I'm sorry.
Copy of the further affidavit dated?
It is affidavit dated on 31st March 2022.
Okay, 31st March 2022. Be served on consent of the petitioner.
I would.
In the course of the day. Let's go on. 17th May. No, we'll have it on 10th May. 10th May.
Supplementary list item number 15.
Because virtually this is a PIL. There no charge sheet has been filed.
Who's in? He'll cover something. Already go. Report, status report is filed. There is.
That was nothing more is coming out. No, charge sheet has been filed. It has been kept. It has been kept pending. We have to see that whether any other active persons are involved in this crime or not. Last two paragraphs.
Vinay Krishna Kabila, SPCID CB Orissa has filed a status report dated 6th April 2022. He states that after the transfer of the previous investigating officer, he has taken charge of the investigation, during which he has re-examined the victim, the complainant, and her neighbor. It is stated, open quotation, but so far no substantive evidence has surfaced to prove the involvement of other accused persons in this case, as alleged in the FIR. Stop, unquote. It is stated that the investigation, open question, has reached at a logical conclusion. On due analysis of the evidence collected during the course of further investigation. Stop. It is stated that the investigation is likely to be finally closed within a short span of time. List on. We'll have to the opening. We'll have to the reopening.
Disposable. I'm sorry, this said not audible.
27th June.
Oh, yes.
Yeah. The report. You see, the status report has been, that has been produced, placed again in a sealed cover. Right.
Supplementary list item number 17.
May I please, Your Honours, Malad, I beg to appear. Malad, pursuant to Malad's direction, the tax department has now furnished the sanction. And in fact, if my lords could see the sanction in the last two matters first, I read petition 6378 and 6395, they are identical. Because there is virtually no sanction at all. Because this is a case which falls within 4 years, so the sanction should have been from the joint commissioner or the additional commissioner. Please see, my lords, page 1, the sanction. This is approval under section 151, which has been produced. Well, the commissioner says since the range head has already approved under 151, there is no further approval, but there is no approval from the range head. Because he, the range head, the joint commissioner, is actually a recommender of the approval. So the officer, Malad, will see is the assessing officer, ACIT Circle 1. He says, as per reason to believe, dated 27th March 2013. Malad, have that?
Which page is that?
Malad, page 1 only of this. They filed separate compilation for each matter. Page 1, Malad, will have, this is a pro forma table. Approval under section 151. May I share it on the screen, Malad, if Malad's permit? Malad, the host will have to enable me. I can then share it on the
that
screen.
Will do. Do you have a copy here?
Yes, I've given. I've given on 28th March 2022.
Okay, you share it on the screen.
And there is also enclosed Annexure 7, 151 order. Sanction order is communicated.
Well, let me just share the screen, Malad. Can Malad see now?
Yes.
Malad will see.
169, Annexure 7.
Malad, this is the approval. May I show, Malad? Well, this is the approval.
Yes.
This is the proposal by the assessing officer, my lords. And just see, my lords, it says approving authority first, PCIT, CIT. Proposer detail, Shishir Kumar Dash, ACIT Central, ACIT International Bhubaneswar. He is the assessing officer. Now, my lords, the recommendation details are, this is the recommending authority as per them. And then please see, my lords, the commissioner's notings. Since the range head has already approved under 1, there is no need for further approval. So as per the department, the approval should have been from the commissioner, although according to me, that's not the case. But the commissioner doesn't grant any approval. There is no approval from the joint commissioner also. And my lords, I'll scroll down whatever they furnished to me. And my lords, another thing which has come to notice, my lords, is that the material which forms.
Are these in our paper book? I didn't find them. Which is showing. When did you file it, Mr. Chimanta?
I've enclosed order under section 151. Proposal for reopen the assessment under section 147.
Right. All right. Yes.
And first
This is now
page
today handed over.
especially mentioned that CIT International Taxation TP Kolkata BBN, Mr. Gaurav Konija, on the basis of reason reoccurred, I have satisfied that it is a fit case for reopening under section 147 of the Act. Approval under section 151 is granted. Approval is granted, which has been acknowledged as an Annexure 7 in the petition itself.
No, my lord, I'm sorry, my lord, my learned friend is maybe reading for the other years. I'm on my lord's read petition number 6378 and 6395.
No, there is no approval. No, he's filed documents in that.
Yes, my lord. 6378, the ones which we have been provided, says there is no approval. He says there is no need for an approval.
I have given for all the 5 assessment here.
Is there an interim order passed by us?
Yes.
Please, my lords.
Interim order.
The interim order is there. In fact, my lords, what has happened is what is more disturbing, my lords. I'm not hanging my hat on this technicality, my lords. That it is an admitted position that the officer has not produced the entire material before the sanctioning authority. What he only does by an email is send the reasons the commissioner by a stroke of line says approved in the first 3 years. In the last 2 years, there is not even an approval. He says no approval is required.
I have given the document for all the 5 years.
No, but he says no approval is required. You want to take instructions, Mr. Chivanka? I don't think he has an explanation. That's why. The problem is that, Mr. Jolly.
Please, one more point, if my learned friend is seeking instructions, is as per the department's own portal, this officer in Bhubaneswar never had the jurisdiction to issue the 148 notice.
Right.
It is by the Delhi officer. Malad, may kindly see page 163. He can take instruction. These notices have to go.
Then I'll take instruction note.
Mr. Jolly points out that in some of the so-called approvals, there is in fact no approval, with the endorsement being that no such approval is necessary. To stop further, he points out that the approvals have been granted by the superior officer, not in Delhi, but in Bhubaneswar.
No, my lord, I'm saying the officer who's issued the 148 notice is in Bhubaneswar. He has no jurisdiction to issue me a 148 notice. My jurisdiction lies in Delhi as per the department's own portal.
All right. You say the jurisdiction relating to the petitioner lies in Delhi, whereas the officer in Bhubaneswar has issued the notice under section 148 of the Income Tax Act, 1961. Paragraph. Mr. Chimanka states that he needs time for instructions. At his request list on 6th July 2022, the interim order to continue till then.
I'm grateful, my lords.
Supplementary list item number 18.
18 and 19, it arrives in the composite order. Here the
delay is how much?
The delay is 45 days.
All right. Both matters?
Both matters. Your Lordship, I only need some time because the tribunal has considered this case of the earlier order passed by tribunal. And all the same, I have in paragraph, running page 14, paragraph 14, we have stated that we have challenged before this court. But evening blood, I am not able to take instruction.
Counsel for Mr. Satpathy, learned standing counsel for the department, needs time for instructions on The connected matters.
Yes, that is I have mentioned that we have filed, but I have not reserved the file in the
And
evening.
its
So
request list on, say, 6th July.
both are the same, right?
Yes.
Supplementary list item number 20.
May I please your lordship? The appellant is a builder and maintain books of accounts which are audited by chartered accountant. No fault had been pointed out in accounts. The appellant had followed consistently the completed contract method of accounting, and the revenue has accepted the method over the years in the past.
All right.
Gross profit is always calculated on sales and not on stocks. Estimated on net profit by the tribunal on unsold closing stock is treated
No, but we've
at the
already
rate of
framed the
6.
questions.
My lord?
We've already framed the questions.
Yes, sir.
So you have been consistently following the percentage completion? No.
No, sir. Percentage, not in percentage. Completed contract, completed.
Completed contract.
Yes, sir. Yes, ma'am.
And previous 2 years it's been accepted.
My lord, that is previous 2 years, my lord, he has not.
In Annexure 6.
So that has not been considered. You lordship see the tribunal order. Running page 18.
Yes.
But the CIT appeal reduced to 6.45. Your lordship see start from running page 19. We also noticed from the order of the AO that ASSI did not cooperate during the course of assessment proceeding for subtracting the valuation of stock, closing stock as shown in the profit and loss account. Further, as per the profit and loss account filed before us, the SSC paper page 6, we find that a gross profit assesses comes to 6.45 on the SSC's business for the year under consideration. So it is his case that it is 4.45, 6.45.
My lord, there
Therefore,
is
in
no
considered opinion, the authority below should apply GP rate of 6.45. That is admitting his profit in 6.45. Therefore, tribunal says 6.45 is restricted to 6.45.
My lord, admitting in a ratio is not in law. There is no rule and regulation. The ICDS is also not applicable in that year. The ICDS is applicable from 1st April 2016. Our case is for the year 14 and 15. And AS7 is also not applicable for a builder. On which basis the tribunal add that unsold closing stock as a sale and make the demand.
Once he's admitting, my lord, he cannot take others. He's admitting that 6.45 in his bookshop account. He's admitting 6.45 in his bookshop account. Therefore, he cannot not take others issue, because if somebody has accepted the profit margin 5% or something like that, he cannot reduce the same and filing of the appeal and something like that. Once his profit margin admitted by the assessee himself in the bookshop account, and that has been considered by the appellate authority, first appellate authority, second appellate authority, and consistent views plot the 6 assess business for the year under consideration. Therefore, as per a consideration, the authority below should apply the GP at the rate of imping on 6.45, accordingly restrict the addition 6.45. Earlier, the assessing officer are restricted to 15%, that has been reduced to 6.45.
On which basis, sir? Without sale, how you can consider it as a profit? Normally, net profit is calculated on sale. With in unsold stock, how we can assume that it is a profit? That is unsold stock. In a unsold stock, how we assume that it is profit?
No, this is estimation.
Unexplained. Unexplained. Yes, not explained before the OIV. In my written note, I have stated in para B.
So that is, sir, my lord, The accounts, there is even learned AO or tribunal, no one not point out any single defects in accounts, not invoked under section 145(3), that is rejection of books of account.
So, but how do you apply a profit percentage to a closing stock?
ICDS is applicable in next assessment year, not in that year.
How do you apply profit percentage to closing stock?
That is
All right. This is an appeal by the SSC directed against an order dated 11 September 2019, passed by the Income Tax Appellate Tribunal, Cuttack, IT80, in ITA number 255/CTK/2018, for the assessment year 2015-16. While admitting this appeal for hearing on 25th November 2021, the following questions were framed for consideration. Paragraph. Background facts are that the appellant firm is engaged in real estate business and is also a builder. To stop, its accounts have been audited as per section 44, capital A, capital B of the Income Tax Act 1961, bracket Act. So for the AY 2015-16, the gross total income was disclosed as 808,190 and taxable income as taxable and the tax, which is also its taxable income. Full stop. By way of self-assessment, in terms of the return filed on 1st October 2015, the SSC paid towards rupees 273,948 towards tax and interest. The audit report is also uploaded on the income tax portal. Of the return of the SSC was processed under section 143, bracket 1 of the Act. Subsequently, a notice under section 143, bracket 2 of the Act is served. To stop, the SSC appeared before the income tax officer through counsel on 25th September 2019 and filed its audited accounts, copy of bank statements, copy of computation of income, and ITR-V. To stop. A written submission was also filed by the authorized representative, bracket AR, of the appellant. Paragraph. It is stated that without affording an opportunity to the appellant to produce its books of accounts, produce the relevant documents or records, the ITO passed the impugned assessment order on 28th December 2017. It is stated that the SSC has been consistently following the single quotes completed service contract method, unquote, which was also accepted by the department in the preceding years. To stop, there has been no change in the method of accounting stroke revenue recognition. Full stop. Nevertheless, in the assessment order, the AO ITO estimated the profit at 15% on the closing stock of rupees 188,08,700. Paragraph. In the appeal filed with the SSC before the Commissioner of Income Tax, bracket appeals, bracket CITA, SSC did not succeed, since CITA affirmed the order of the AO.
Restricted to 6.45.
The CITA.
Restricted to 6.4.
All right. The CITA restricted the profit percentage to 6.45% of the closing stock. The impugn order of the IT-80, in the impugn order, the IT-80 declined to interfere with the order of the CITA. Paragraph.
No, sorry, 15%. Is that? Sorry, sir.
CIT
The
appealed
IT-80
15%,
reduced.
IT-80 6.45%.
The IT-80
confirm the order.
has reduced the net profit to 6.45% of the value of unsold closing stock. Paragraph. This court has heard the submissions of learned counsel of the parties. Paragraph. It is pointed out by learned counsel to the SSC that on the unsold closing stock, no profit percentage could have been applied to arrive at an estimated profit. So, in other words, submitted that without sale of the commodities, the question of estimating a profit on the basis of a percentage of such sales would not arise. It is further pointed out that the audited accounts of the SEC have been accepted by the department. And therefore, there was no logic in going in for an estimated profit on the basis of the valuation of the closing stock. Paragraph. Mr. Satpathy, learned counsel appearing for the department, sought to submit that it was the SSC's own case that the net profit would be 6.45% on the value of the unsold closing stock. And that since this was an admitted position, no interference was called for. Paragraph. Having considered there was sufficient support of the view that there is merit in contention of the SSC that there cannot be an estimation of net profit on the value of single quotes unsold closing stock, without there being actual sales, without there being actual sales of the closing stock, it would not be possible even to estimate the net profit. Moreover, there has been no rejection of the books of account of the petitioner, which reflects the method of accounting followed, namely the completed service contract method, and not the percentage completion method. This too was lost sight of by the IT-80 as well as the CITA. Most of this has been the consistent practice of the petitioner and was easily verifiable from the returns already filed for the earlier AYs. Paragraph. In that view of the matter, the questions framed by this court are answered in favor of the SSC and against the department, but holding that the IT-80 was not justified in following the percentage completion method for calculating the profit of the SSC, the AY in question, and determining the net profit at 6.45%. Stop. The IT-80 also erred in declining the appellant SSC an opportunity of producing its books of account. The impugn order of the IT-80 and the corresponding orders of the CITA and the AO on this point are hereby set aside. The appeal is disposed of in the above terms.
Supplementary list item number 21.
Thank you.
May I please, Your Lordship? May I please, Your Lordship? The present appellant convicted under section 302 IPC for life, my lord, but in the meantime, the present appellant granted premature release by the state government. So petitioner does not want to.
All right. The appellant is stated to have been released prematurely by the state government. Consequently, he does not wish to press this appeal and is disposed of as such.
Supplemental list item 22. Item number 22.
What time?
On last occasion, a lordship was directed to issue bailable warrant, my lord. Since the appellant was not found, my lord. Lordship may kindly see in the first page the additional district judge, additional district judge Chhatrapur, enclosing the copy of the warrant of arrest, my lord. In the second page, directed the SP to lord to issue to arrest the accused appellant. But my lord, the IIC Kabishwarinagar in the last page said that he is not found in the village, and on his investigation, it is found that he is staying somewhere in Andhra Pradesh.
So we'll pass a same order. Whenever he is arrested, we'll review the appeal. Earlier first. The petitioner was released on bail. The petitioner's command was in this appeal challenged an order of the trial court convicting him for the offence under section 302 IPC and sentencing him to imprisonment for life. And also pay a fine of 300 and in default to undergo imprisonment for 3 months. Was granted bail by this court by an order basis. What is the date on which bail was granted? Just paper book. The order dated 16th March 2010. Full stop. When the appeal was taken up for hearing on 11th November 2021, when none appeared, notice without process fee was asked to be issued through the SP Berhampur. Again, on 10th March 2022, none appeared. A bailable warrant was asked to be issued through the SHO of the concerned police station for appearance of the appellant before this court. It was made returnable today. The report has now been sent by the SP Ganjam, Chhatrapur, enclosing report of the IIC Kabisuriya Nagar PS. Wherein stated as under A to A. Even today, none appears to the appellant. So, with the appellant having gone absconding, The bail bonds furnished by him are cancelled. Since the appellant is consistently avoiding appearance before the court directs that the present appeal shall stand disposed of, with the further direction that as soon as the appellant is apprehended and taken into custody and sent to the jail, an application will be simultaneously moved by the state before this court for revival of hearing of the appeal.
Good. Supplementary list item number 23.
This is such how the spread for a pastor.
Correct. Correct.
Supplementary list item number 24.
24, I have prepared a short note
Yes.
for your lordship's convenience.
Yes.
Lord, I am before your lordship for recalculation and revaluation of my paper 2. I was a candidate for your district judge examination from the bar in 2016. May I place the note?
Send this redirection to somebody else.
Yes, ma'am.
First of all, there's a totaling mistake. It should be 45.5. It's been indicated as 43.
Even if for the sake of argument, your lordship may kindly take it as 45.5. Even then, your lordship may kindly, that is his case also, your lordship may kindly turn to first the advertisement at page 42. 42, relevant portion is at page 44.
Yes.
Clause 10, examination, subclause 2, interview.
Yes.
Candidates shall be called for interview in proportion of 1:10, provided that such candidates have obtained at least 45% marks in each of the written papers and 50% of marks in aggregate. So he has to obtain 50% of the marks in aggregate. Now, your lordship, kindly see his pleadings. Paragraph 9, internal page 5. That on verification of his answer script, he found to have secured 53 marks out of 100 in paper 1 and 43.5 marks out of 100 in paper 2. He was satisfied with the mark of paper 1, but on calculating the marks given in paper 2, he found to have secured 45.5% marks.
See, if he's given 4 more marks, he said 5 more marks.
No, his case is that instead of 43.5, I should have been given 45.5.
That's only for totaling. Then there's one more point being made. In both the answers, he has answered part of the question correctly.
Yes.
The first question was on anticipatory bail in SC/ST Act. And it says discuss with case law. He has correctly said there is no anticipatory bail and is given the name of a case. He has not discussed case law. But he's been given only 0.5, which is half a mark.
But that is the subjective satisfaction of the evaluator.
No. That's where the point is. Whatever subjective satisfaction, when you answer one portion of the question, can you just give 0.5? 0.5 seems to be unreasonable. And the second question also, procedure for fire trial under the PC Act. No doubt it's a 5-mark question, but he's given the right answer. See, that he has not been elaborate about it.
Will also may consider in paragraph 6 and 8 of our counter. Will also pass appropriate order.
No, appropriate order meaning what? You tell us, because it's the 2016 selection.
Yes. Now it's not possible.
No, is it or is it not? That's the only question.
My lord, it is possible.
How?
In view of the, my lord, since
Well,
there are
vacancies might have been carried out in the meantime.
Vacancies are there.
Vacancies might have been carried out, might have been filled up in the next year.
No.
I don't think there are vacancies have been filled up.
No.
There are unfilled vacancies. Every year there's unfilled vacancies.
So far as 2016 vacancies concerned.
We are on 2016 vacancy. Can you find out about that?
The vacancy I have given the information. I have
Last time.
Last occasion I have given the.
Out of 9 candidates, only 9 posts were advertised. Only 3 could be successful in 2016.
Well, that is instruction dated 22nd December 2021 of the Special Officer Administration.
Of the 56 vacancies, 19 are meant for direct recruitment to the bar. 19 are to be filled from limited competitive examination. And 18 from usual promotion. The usual promotion has been filled up. See, this vacancy in the post of district judge is always unfilled.
Yes, that also I have given, supplied the information.
It's all unfilled. The promotion quota is filled, usually direct recruitment and limited competitive. LC quota, both are not filled.
19 vacancies are meant for direct recruitment from the bar. Out of 56 vacancies till 31st March 2022.
That's right. It only says 19 are meant for direct recruitment. That is this year's vacancy. Because he'll only end up being called for the interview then. He was not called for the interview because of this. See, he will join the interview, this time's interview. Place it before an evaluator. We'll place it before the committee, whether it wants to relook at the answers. All right. The answer script of paper 2 of the present petitioner be placed before the examination committee for two purposes: (1) whether as claimed by the petitioner there is a totaling error, inasmuch as the petitioner should have got 45.5 marks and not 43.5, semicolon, and 2, whether in respect of the answers to question number 1, the answer to question number 1 of group D and question number 3 of group D, he should be awarded more marks than 0.5 each. Question mark. The decision of the examination committee be placed before this court on the next date. Full stop. In the event, in this regard, we place before the court. The committee will also give its view on whether, in the event of the petitioner scoring more than 47% marks in paper 2 as a result of the above exercise, thus in the aggregate of paper 1 plus 2 securing 50%, that is 53 plus 47. No, securing 50%, whether he can be called for the interview along with the current successful candidates in the current selection for Viva OC. It's on 27th April. 27th April.
April, my lord. 27th April.
I don't know what's the schedule. Do you know the schedule for the current exam?
No. Examination is over.
April. 27th
April, my lord. Oblige.
Supplementary list item number 25.
May it please your lordships. Lords, in this matter on the last date, the lordships had said I had mentioned that I'll put in my written submissions.
Yes.
Written submissions, my lords, can I just tender it across the court, my lords? I couldn't file it, or I can file it today, my lords, whatever, my lords.
All right.
It's along with two judgments.
There are two judgments, the sale judgment and one judgment of the Delhi High Court, my lords, on this point. Both of those judgments are also there.
You have a copy, Mr. Mishra?
Yes, a copy of the judgments are not there, but the note has been.
Judgment is mentioned.
Millers, I am appearing for CCI. A copy may be favored to me.
I'll serve a copy on it. I'll serve a copy.
All right. The written submissions of the petitioners have been today handed over. Copies thereof be furnished to Mr. Shaktidhar Das, learned counsel appearing for the senior counsel appearing for the CCI. Mr. Gautam Mishra appearing for Steel Authority.
For Paradip.
Paradip Port.
Paradip Port Trust has also been provided with a copy of the written submission.
So I think the third matter is no longer relevant. The third matter can be disposed of in this batch.
Okay.
I think Mr. Panigrahi will agree.
No, I will not have an objection, my lords, as a housekeeping that has to be, because my lords, what had happened was initially orders were, this court passed orders and there was one which was filed in defect. So the last matter can be dismissed, my lords.
All right. 3454.
Not pressed, my lords.
2018. This is disposed of is not pressed. Right. This
And
petition is
in fact, the lead matter can be 5326 because if they succeed there, then 8358 may be relevant.
He may be right there, but my lords, what had happened was while 5326 of 2017 was pending, my lords, the CCI went ahead and then passed the order, penalty order.
Right.
So which is a matter of the subsequent writ petition, which is 8358. So whichever way, my lord.
The third matter, Millers, is can be.
No, that is over, sir. Third matter is over.
Let it be. Both matters, let them come together. Let him address in his own.
All right. So when do you want it?
As any time.
We'll have after the opening then.
As your lordship, just a copy may be given to me.
25th July, sir. 25th July.
Dismissed.
Right. Weekly we can take it in the afternoon. Yeah. Is somebody there? We can take it. I don't think anybody's here for the weekly. If 3 or 4 council turn up, then you send word and then. Otherwise,
Lords, can I make a request in item 25? Sorry, before my lord.
No, tell me.
My lords, 25th is a Monday. Can I request for 26th? If it's...
All right, 26th. All right. All right.
Keep your pleasure.
My lord, in compliance of the last order, I have filed an affidavit with annexures in terms of the directions made in para 8 and 9 of the last order. And that is filed on 3rd April 2022. I have soft copy on all my learned friends appearing for the petition.
Where is that?
Mr. Dolai, I have not served. I am just now serving.
It's not here. This is it the affidavit of the collector?
No, this affidavit, the direction was given to place on record by the SP, the local IIC, who is supposed to keep the records, and he has shown the affidavit on the for and on behalf of the SP.
Can you give us a copy? We don't seem to have it here.
It is already filed on 3rd April 22 in counter. In counter we have, because on that particular day there was no e-filing. I am filing another copy. Out of it.
Yes. So annexure A, annexure B, annexure C.
My lord, there is another direction of this honorable court. Pardon?
Your point is that all 30 have criminal cases?
Yes, my lord.
No, but are they needed for any of these criminal cases? Their names are mentioned. I mean, they must have already, investigation must be already over in these. These are all November 2020
No, charge sheet
cases.
has not been submitted, but I can produce the case diary, the status of the case I can produce if your lordship so direct.
No. We don't want to go into that detail. Just asking, are they required to be arrested in these cases or what?
Okay.
Or if they cooperate in the investigation, that is enough.
And most of them didn't have the knowledge that they have been implicated in this.
My lord,
and only
small submission on my part. In all these cases, all these persons They have already been granted anticipatory bail in the High Court.
Then there's
All
no
these cases.
then there's no
Only
apprehension
in
at all.
one,
Then
PS case number 127,
so
they haven't got.
see, no case has been registered for the 14th incident against any of them. These are all old cases.
Old cases. They have to get anticipatory bail in all these cases.
He says they've already got it.
The fact being, the common thing is section 307 in all these cases. The informant is always the.
We are not examining all that here. We just wanted to know. We wanted to know what is the background to all these people.
In all these cases.
No, that's right. But we just wanted to know what the background was. The number of persons arrested after 14 are 17 persons.
Out of that, in 5 cases, they were not named in the FIR, and they were under the category of others.
All these details are with all of you now.
Yes.
The complete details are there, FIR numbers, which sections are involved. The complete details are there.
And 8 persons are inside custody, my lord, relating to this.
They have already applied for regular bail. That is taking its own course.
All relating to this protest against JSW.
Maybe, but that cannot be decided here. They are
that's all right.
under 439.
See, it's important to know that they are identified persons with cases against them, so that you take a call on how you advise them and what they want to do.
Yes.
At least we have all the details. You have all the details, because earlier you were not aware what the cases were and all that. Now you have the complete details.
This all relating to the protest against JSW.
Have all of you submitted your affidavits?
My
lord, in the meanwhile, that is what I was trying to
53 persons
submitted
their affidavits.
Pursuant to your lordship's directions, as on date, I have received this much of affidavits. And I will convey it to the collector Cuttack. She will send it to MOEF as per the direction. Because I was waiting for today. Till date, I have received this much of. From tomorrow, I will not receive any more.
Small submission on part. Today I am submitting 300 affidavits.
300?
300 affidavits.
If my lord gives me...
This can't go on and on, Mr. Devdas. Will sometime it will come to an end.
Sufficient opportunity was given to him. He is the petitioner and he has not served copy of the...
In the course of the day, I am submitting the copy.
How can it be? By today, you should have submit all this, because I have to go through those affidavit. Who are the persons who have shown the affidavit? And 1 month time passed in the meanwhile. You are the person who is the petitioner's lawyer, and you should be vigilant. Some lawyers, your lordship will appreciate, some lawyers who are not parties to this case even, they have filed affidavits pursuant to your lordship's direction. And today he is saying that in course of the day, I will file 300 affidavits. My respectful submission is that should not be accepted. That's all.
I am appearing for opposite party number 9, my lord. I am also, my lord, in virtual, my lord.
Yes, Mr. Mantri.
I have a small submission, my lord. My lord, in this case, environment impact assessment has been done, public hearing has been done. Investment Appraisal Committee has made its recommendation, which your lordship is also reflected in the order, earlier orders, order, my lord, in paragraph 6, my lord.
Yes.
That it is pending with MOEF.
Right.
Now, my lord, last time also during the POSCO, it took a lot of time for getting that clearance, my lord. So,
anyway, it's now for the MOEF to take a call.
Now your lordship may direct the MOEF to dispose it up within a particular period. That is all.
You're not granting any relief that way in these petitions. In this petition, actually, we never issued notice to you because of that.
That's right.
So let the MOEF take a call on all these affidavits.
My lord, as on date, whatever affidavits I have received,
you
right
take
now
this. Another 300 is there. If you've got it with you.
Yes.
I may be,
okay.
I may be, pardon my lord, I have also filed one intervention application, that is IA number 4598 of 2022. That may be...
What is it? Who
he has filed certain affidavits. I am sending it those affidavits, no issue. But
my lord, intervention application in support of the project activities against the Gundaism of the local people.
Anyway, there will always be 2 points of view at least.
My lord.
So let everybody submit whatever has already been submitted. Today is the deadline.
Yes.
not beyond today.
Yes.
My lord,
That
I have
your lordship
already
may kindly
filed.
note.
I have already filed, my lord. Let it be.
Yes,
come
I
with
have
director.
received and I will send.
I have
it.
already served the copy to the Petitioners Council and the
All right.
State Council, my
All
lord.
right, all right.
I have something to submit, my lords. I have also filed an application. My lords, I have also filed an application for being implemented as an intervener. I have also served the copy on my learned senior, Mr. Mahanti. That may be taken into record, my lords. IE number 4599 of 22.
You see, a detailed affidavit has been filed by the Superintendent of Police, Jagat Singh Pur, placing in record details of the criminal cases involving the 4 persons who were not found in the village. In terms of para 8 of the court's order dated 11th March 2022. He's also filed the details of the criminal cases involving the 30 persons whose the list of whom was provided by Mr. Jena, and which was mentioned in para 9 of the aforementioned order of this court. The details of the persons arrested after 14 January 2022 and the cases in which they were so arrested have also been set out in a separate enclosure with the affidavit paragraphs. Mr. Devdas says that apart from the affidavits already provided to Mr. Manti, Learned AGA, he will be today furnishing 300 more affidavits. Meanwhile, there are 2 intervention applications being IA numbers
4598 of 2022, my lord.
4598 of 2022
4599
and 4599 of 2022.
And another, my friend, is also
My
submitting.
lord, 4581 of 2022.
4581 of 2022. The affidavits filed with all these applications have already been handed over to Mr.
Yes,
Monti.
I have received all.
Paragraph.
But not Mr. Devdas affidavit. 300 affidavit he supposedly.
Yeah, Mr. Devdas will furnish the 300 affidavits to Mr. Mohanty positively by 5 p.m.
By 4 p.m. my lord.
By 4 p.m. today.
Yes.
It is made clear there will be no further extension of time for any further affidavits. Paragraph. Mr. Mohanty states that all these affidavits will be examined, handed over to the collector, and who will in turn forward them to the Ministry of Environment and Forests and Climate Change, Government of India, for appropriate action. Paragraph. The purpose of the court entertaining the present petition has been somewhat served with the complete details emerging and persons who were apprehensive that their voices may not be heard, having been given adequate opportunity, either in the form of an oral hearing in the site itself or by way of affidavits. At this stage, the court does not further, the details of the cases involving the persons who have been arrested and who are apprehending arrest or are all available now with the concerned persons through their advocates. Stop. The court would not like to comment one way or the other on any of the said cases, as they will be subject matter, that as they would be at different stages pending before different courts. Full stop. The court accordingly dispose of this matter, disposes of this petition.
My lord, the collector's appearance is in VC.
May I frame, Lord?
Collector is in
One
VC.
thing, Lord, all
and
these three
the additional SP and IIC both are physically
All
present. Your lords may kindly.
Right in the beginning, you said the collector, Jagat
all
Singh
these,
Pur,
Lord, all these
the
three
IIC
IIC Abhay Chandpur PS and additional SP Paradip.
and additional SP Paradeep are present.
Lord, all these
And
PRs
collector on VC.
Yeah.
May I submit, Lord, one thing, Lord? All these three PLs focusing on the police atrocity and specifically on 14th, my lord. We expect, my lord, Lordship, if so pleases, my lord, have a
There are
finding or
cases registered. Let the cases take their own course. All right. We can't comment on that. This is a writ jurisdiction. It's better that the cases take their own course. All right. The petitions are accordingly disposed of. All right.
Supplemental list passed door matter. Item number 23.
Who's in 23?
Item 23.
She took an adjournment last time. No? The same matter. She wanted to prepare a detailed note and all that.
Item number 23. JCRL 60 of 2006.
My pleasure, Lordships. Lord, this is a matter. Last time we have been already placed before good self that my client is nowhere connected to the matter, and he has been by chance involved in the matter. Unfortunately, he was inside the bar till date. Neither he made a call, neither he made an application through the jail welfare officer for a bail or anything, because he was highly depressed. For no fault he is suffering. I am telling this from the experience of Dara Singh, the international crime of Graham Stens matter. I am the first lawyer of Dara Singh. And he was when convicted in court below, he denied to come for the appeal. And for him, I had been to the Baripada and got the Okalatnama, and convincing him, I filed the appeal. And from hanging for death sentence, he converted to life. If I could have been to go to Supreme Court, I have 100% cause and descriptions that he is no way connected to the case. For that, I am telling that it is now the person has been behind the bars for long 17 years. The conviction period is about to over. Wasting of time of this honorable court should not go for that. And as for your lordship's desire, can pass an order.
All right. Orders reserved. All right.
I am obliged.
All right.
Weekly list old matter. Item number 1.
Bail was granted on 9th May 2012. So what is your instruction? 4/1/21 order.
But today in the morning also I have again reminded them. By next Thursday, my lord, the instruction will come.
All right. At the request of counsel for the state, list on next Thursday, by which date the information regarding the appellant would be provided to the court.
Well.
Hmm? 21st, correct. List on list.
Weekly list old matter. Item number 2.
May I please, Your Lordship? Here in this matter, my lord, the appellant had conviction under section 302 and 34 IPC, my lord.
for life, my lord. And there are only one eyewitness, my lord. PW 22, my lord. May I please read to my lord?
Yes.
In the last PW 22, my lord, Bhola Das. In the last summer season, at about midnight, after watching TV in the house of a person, my lord, if I found both the accused person and Babu is the deceased, my lord. Both the accused person and Babu were quarreling and pulling and pushing each other. I intervened, and with Babu, I was coming to our house. Accused Diku Soren assaulted by Thenga to Babu, and after he fell down, both the accused person assaulted him by hand and by means of a brick. I went to the house of Babu and called his younger brother of Babu, whose nickname was Bappi. With the help of Bappi, I carried Babu to his house. Babu was screaming, saying, "Motte marichanti, mu tanku mari debi." Babu died. Cross-examination, my lord. I was the son of Mausi of Babu. Prior to the incident, I went to the house of Babu on Tuesday. I cannot give the date. I went out at about 3 or 4 p.m. from house of Babu. After moving in the fertilizer town, I went with Babu to watch film. I cannot give the name of the person to whom house I went with the Babu to watch the TV. Babu drank liquor on the date of incident. He also took drink. I had also taken the liquor. I cannot give the date of incident. There was road light in Balijodi village. I cannot give the number of road light in the Balijodi. Prior to the incident, I did not know the accused person. I knew the name of accused person when Babu was screaming and saying that the accused person assaulted him. So also I knew their name after their arrest by the police officers. I was at a distance of 10 feet away from the place where the accused person and Babu quarreled. Myself and Babu were together going. After blow was given to Babu, I also saw he was assaulted by Dikku. There was one brick and one body. When Babu was assaulted, he shouted, saying that of what offense he committed, where they are beating him. Near the place of incident, there are houses at a distance of 5 to 10 feet. I cannot give the time when Babu died after the incident of assault. The Babu's parents, sister were present in the house. I cannot give the time when father of Babu went to PS. I cannot give the time when police officer came. I did not inform any other person about the incident. My lord, this is important, my lord. I did not inform any other person about the incident. I was examined by the police on the date of incident. I cannot say where the body and brick were lying when Babu was brought to his house. Except me, no other person had witnessed the incident. My lord, in this matter, in the PW 22, my lord, did not say anybody's name, my lord, the accused name, my lord.
Bro, Dikku Soren?
My lord, that's he heard from the deceased man.
That's right. Whatever. But he's mentioning and he's identifying Dikku.
But he did not say anybody, my lord.
No. Why are you saying that? Just see the fifth line from the top. Accused Dikku Soren.
My lord.
Identified in the doc.
Well, kindly says, my lord, PW1, my lord, the informant, is the father of the deceased man. PW1, my lord, Panchulenka. I know the accused person. About 6 months back, at about 1 a.m., my godson Bhola came to my house, knocked the door, and called my younger son Sumanta to go with him to bring my eldest son Susanta. Sumanta and Bhola brought my eldest son, whose nickname was Babu. I found bleeding injury in his neck side and front side head, chest and hand. At that time, Babu was screaming, sore, and Soren and Mudgu had assaulted him, and he would assault them. I found thereafter he became senseless and collapsed. He died after some time. I got a report written through a person of the locality and lodged the same in the PS, knowing the contents. Exhibit 1. The police officer came for investigation. Cross-examination, I do not remember the date of incident. The incident took place in the month of Jesta. By the time I went near my son had already died. This line, my lord. By the time I went near my son had already died. It is not a fact. Babu did not scream Babu screamed, saying Soren and Mudgu assaulted him, he would assault them. I instructed the person who scribed the report lodged before the police to mention therein that Babu screamed, saying Soren and Mudgu assaulted him and he would assault them. But I do remember it that person so mentioned in the report scribed by him or not. In the FIR, my lord, nobody name was there, my lord.
No, why are you saying just see come to the next witness, DW2?
DW2, my lord.
PW2, yeah.
The brother of the deceased, my lord. Manmat Linka. I know both the accused person on 1/4/2004 at about 1 a.m. Bhola, a friend of my elder brother Babu, Susantalinga, came to our house and called me to go with him to bring my brother Babu. I went with Bhola and found my brother Babu was laying on the roads in front of a house of Hemanta Mahapatra. Oh. Somebody. Of Bali Jodi with bleeding injury on the backside of the head, face, and forehead. And my brother Babu was screaming that they had assaulted him and he would assaulted them. Myself and Bhola brought my brother Babu to our house. We administered water to him. In our house, he screamed, saying that Dikku and Mudgu Tudu has assaulted him and he would assaulted them. Thereafter, he died. I inquired in the Basti and learned that Dikku and Mudgu assaulted my brother and fled away.
So again named, they're all named, sir. What is the doctor's postmortem?
Doctor's postmortem report, my lord. The brick and the stick, there was no blood stain in the...
That's all right. That's all
PW 17 at page 57.
Multiple bruises, sir.
My lord.
Multiple bruises. Injury on head. Page 58. All the injuries are antemortem in nature and cranial cavity contain blood and
one
blood.
incised wound.
Yes.
Scalp deep, present in the occipital tissue.
Cause of death was due to head injury.
Possible, except the inside wound, my lord. One paragraph was that on 12/4/2004, on the basis of the query of the investigating officer on production of brick and wooden stick lathi, I examined the same with a reference to the PM report and had given my opinion, White Report Exhibit 8, to the effect that the injury detected on the dead body of Susanta Kumar Lenka could be possible except the inside wound.
That's right. That weapon they could not recover. That's what it means. It couldn't recover the weapon they used for causing that injury. Tenga or whatever they call it.
But there was one lathi and one brick, my lord.
No, Tenga is what?
Lathi, my lord. Lathi.
And the fact that he's got this injuries can't be denied.
And PW 24, the magistrate who was present during the TI parade, my lord, he has stated at page 73.
Yes.
Page 74, first line, your lordship. He was asked to identify the culprit who had taken active part in the commission of murder of deceased Susmita Lenka. The identifying witness Bholanadas identified both the suspects Madgu Tudu and Dikku Soren as culprits who committed murder of deceased Susmita Lenka out of the persons standing within the suspects. Accordingly, I prepared this report.
They all are watching TV, my lord. Of some Ranjita, but he was not examined, my lord, but he was declined.
It's all right. Anything else? Nothing else. This appeal is directed against the judgment of conviction and sentence passed by the dated 15th April 2005, passed by the Additional District and Sessions Judge, Fast Track Court, Rourkela, convicting both the appellants for the offences under Section 302 Red with 34 IPC and sentencing each of them to undergo rigorous imprisonment for life, bracket RI, and to pay a fine of ₹2,000 and in default to undergo RI for 6 months. In ST case number 205/51 of 2004. The case of the prosecution was that on 1st April 2004, the deceased Sushanta, along with Bhola Das, bracket PW24. Sorry, PW23, is it?
No, 22.
22, sorry. The godson of Sushanta's father went to the house of one Ranjita Maji to watch films on her television. Full stop. In the night, there was a quarrel between the deceased and the two accused outside the house of Ranjita. And there was pulling and pushing. Full stop. Thereafter, while Sushanta was returning with PW22 to the house, both the accused persons assaulted the deceased with a tenga. As he fell down, they assaulted him again by hands and bricks, and then fled away. Stop. PW22 went to the house of the deceased, called his younger brother Sumanta alias Bapi to take the deceased to their house. Stop. After being brought to the house, Sushanta died. Stop. Manmat Lenka, bracket PW1, the father of the deceased, lodged the report to the police. The case was then registered and both accused were charge sheeted for the offence under Section 302 Red with 34 IPC. They pleaded not guilty and claimed trial. Paragraph 24 witnesses were examined for the prosecution. Stop the judicial magistrate who held the test identification parade, bracket TI parade, was examined as PW 24. Several witnesses, including PW5, PW6, and PWs 10 to 16, turned hostile. As already mentioned, the informant was PW1 and his two children, PWs 2 and 3. PW4 was witness to the inquest and recovery of the weapons of offense on the basis of the disclosure statement of the accused. The accused were arrested from a village in Kyunjar. Paragraph. The trial court discussed extensively the evidence of the solitary eyewitness, PW 22. And concluded that he was reliable. Although PW 22 was related to the deceased, his evidence was held to be truthful and reliable. The trial court also discussed the evidence of PWs 4 and 8 who were present along with the investigating officer, bracket PW 21, at the time of recovery of the body and the brick used in the assault of the deceased. PW 26, Surendra Malik spoke of the guilt of both accused who remained absent from the village soon after the incident. They were arrested only on 3rd April 2004 from a village in Kyonchar. This court has, with the help of learned counsel for the parties, examined the evidence in some detail. The eyewitness PW22 spoke clearly of the two accused assaulting the deceased with a tenga first and then by hands and a brick. Full stop. PW22 was extensively cross-examined, but nothing useful could emerge from the point of view of the accused. His testimony appears to be natural and probable and also trustworthy. Full stop. Although he may be the son of the aunt of the deceased, his testimony cannot be discarded since it is fully corroborated by the medical evidence of PW22. Sorry, PW. Yeah, PW70. There were as many as 8 injuries on the dead body of the deceased. One was an incised wound of size 1 and half into half inch scalpel on the occipital region. Correct. The medical evidence corroborates the eyewitness testimony in large measure. Paragraph. Learned counsel for the appellant first submitted that the star witness PW22 was not able to identify the two accused correctly. Stop. This is not true at all. The evidence of the judicial magistrate first class who appeared to who conducted the TIP and appeared as PW24 clearly stated that when PW22 was asked to identify those taking active part in the commission of murder of the deceased, PW22 identified both the accused promptly. The role of role of both accused is also spoken by PW's 1, 2,
PW22 has been corroborated by PW1, 2, and 3.
And 3, correct. All 3 of them have named the 2 accused as the persons who assaulted the deceased. Stop. Medical evidence by and large corroborates the eyewitness testimony, and the evidence thereby produced is sufficient to bring home the guilt of both the accused. The identification of both the accused correctly by the star eyewitness, PW22, also strengthens the case of the prosecution. Consequently, the court is unable to find any legal error having been committed by the trial court in convicting both the appellants for the offence under section 302 read with 34 IPC and in sentencing them as aforementioned. There is no merit to the present appeal and it is dismissed as such. The bail bond furnished by the appellant shall stand cancelled. He shall surrender forthwith. If he fails to do so within 2 weeks, the concerned IIC will take immediate steps to have him taken into custody to serve out the remainder of the sentence.
Weekly list item number 3. Weekly list item number 3.
Again, same position. I think we don't know the whereabouts, or do you know?
Yes. What about
show the paper?
there is nothing on record notes. Regarding the whereabout of the appellant.
That's right.
I have to get instruction on that.
No, earlier there was no order for that.
There is nothing on my in my record.
Let me just check. Bail was granted to the present appellant on 28 September 2015. Today, none appears on his behalf. The concerned IIC will inquire about the present whereabouts of the appellant and inform the court accordingly on the next date. Thursday, that is 21st.
Weekly list item number 4.
The counsel for the appellant was absent on last occasion also, and your lordship directed the state council to obtain the status regarding the whereabouts of the appellant. Now, your lordship may kindly see the last order. It was on 10th of March 2021.
So whereabouts?
He is in his village. Your lordship may kindly see.
Counsel for the state informs the court that the appellant is very much in his village. Notice we serve to the appellant through the concerned IIC to appear in court on the next date. But the Secretary, Orissa High Court Legal Services Committee, OHC LSC, is directed assigned for the appellant. The panel counsel not less than 10 years experience. Copy of the paper will be provided by the registry forthwith to the Secretary OHC LSC, will in turn transmitted to the panel counsel who has been assigned the case. This 7 July. Which year is this? Done back?
No.
12th May. You take a chance on 12th May. 12th.
Weekly list item number 5.
Item 5 also similar case, no? But on last occasion, on last day, the Honorable Division Bench stated that if the counsel for the appellant again remains absent, then another counsel will be appointed by your lordship as amicus to you. Lordship may kindly see order dated 17th of February 2021.
None appears to the appellant. Notice without process fee will issue to the appellant to remain present in court on the next date. Notice be served to the concerned IAC. In the same paragraph, the secretary would see the citizen directed to assign accounts. Same date. 12th.
Quickly item number 6.
Can you do one thing in all these cases, because nobody's appearing?
Well,
can you do an inquiry? Do you have to pass an individual order? You can make an inquiry where they are not.
Yes.
From this onwards.
Yes, ma'am.
Because nobody else is appearing. 6 to 10. Please.
6 to 10. 6 to 10. Yes.
8, there is a report of the IAC Yoda Post. Yes.
Item 9.
No.
In that
item 8,
is the instruction whatever.
Item 8, you say there's a report.
8 also, my lord, kindly see the last order dated 22/10/2020. Similar order was directed to my lord, take instruction about the well-being of the appellant, my lord. We have written letter. Today also in the morning I have reminded they'll by next letter. Item 8.
In item 8, there's a report.
In item 7.
IAC Yoda PS. The appellant is very much available in his village and is earning his livelihood. Notice without processing issues to the appellant through the concerned IAC to repeat present code on the next day. This is directed to supply a copy of the paper to the Secretary OC LSC to assign a counsel, panel counsel of not less than 10 years experience to appear for the on the next day. List on same 12.
In item 7, my lord, directed to obtain instruction regarding the whereabouts of the appellant. My lord, he has been released on bail and is alive today and residing at village Rengari.
In item 7 also identical order. This is already an inquiry. Same. 6 also is very much alive. Same order. What is left out now?
Item 9 and 10.
9.
Item 9.
So what we passed because we have obtained instruction regarding the whereabouts. One has died and that is there in the order sheet. Appellant 1 and 2 have been released on bail. And the third appellant has died.
In which one? Chandra Bhumia. That matter. Chandra Bhumia, Sukalu Bhumia, and Guru Bhumia.
Plus Chandra Bhumia also died. Chandra Bhumia also died. Two appellants have died.
Sukalu also died.
Chandra Bhumia. My instruction Chandra Bhumia as well as Guru Bhumia both have died.
So only Sukalu is there.
The instruction I have received on 25th March 2021.
Mr.
Plus I'm passing on the. May I pass on the instruction?
Yes, yes. Oh.
I have highlighted those two names.
The report dated 25th March 2021 of the IIC. Police Station, Malkanville. In custody, Guru Bhumia had died on 2/2008. Apparent number one, you say apparent number 3 Guru Bhumia. Apparent number 1 Chandra Bhumia died 5 to 6 months previous to the said report. Subsequently, Bhumia said to be residing in the house. Notice is our process. Through the IIT consultant. The last paragraph.
Item number 10.
10 must I don't have an instruction.
Concept state 6 times to obtain instructions on the present whereabouts of. Yeah.
Just one matter that Your Lordship has reserved for judgment. That is item 23. Mrs. Raut was arguing that matter. No, sir, I am failing my duty if I will not assist this on court because I am giving 2 judgments here also. The paragraphs I have marked. Item 23, Your Lordship has reserved the matter.
Achha. All right. All right. 21st. Last item is 5th May.